Welcome to this edition of Security and Compliance Weekly. Today, we are excited to have back with us Priya Chaudhry. She's going to facilitate a long overdue discussion on this show about all the legal goings-on related to security and compliance. We're going to cover some issues of litigation, finally get her reading on the Supreme Court ruling on the CFAA case that they ruled on. Gosh, it's probably been 2 months ago now. There's other legislation that's being proposed. We want to get her insights on that. So pretty much we're going to just turn the mic over and let Priya teach us today all things law and legal and privacy. So hear ye, hear ye. Please join us as we continue our journey of tearing down silos and building bridges on Security and Compliance Weekly.
This is Security Weekly, for security professionals, by security professionals. And now, it's the show that bridges the requirements of regulations, compliance, and privacy with those of security. Your trusted source for complying with various mandates, building effective programs, and current compliance news. It's time for Security and Compliance Weekly. Some things are best kept secret. You wouldn't send your company's financial data through the mail on a postcard. Then why would you let your employees use insecure collaboration and file share tools to share sensitive business information? Introducing Crossclave, a file sharing and collaboration solution built secure from the ground up. Think Signal, only designed specifically for business and enterprise users. Crossclave uses blockchain technology and end-to-end encryption to deliver a true zero-trust system designed to protect you and your business's most valuable data. So if you need to share sensitive information, SpiderOak's Crossclave is your only choice. Go to securityweekly.com/SpiderOak and get a free account with 5 gigabytes of storage.
Welcome to episode number 81 of Security and Compliance Weekly, recorded on July 27th, 2021. I'm your host, Mr. Jeff Mann, and joining me remotely as usual are my co-hosts, Mr. Scott Lyons, Mr. Josh Marpet, and of course, Priya Chaudhry. Welcome, everyone.
Is this where we start making really bad law jokes and say, you can't handle the truth? Wait.
We could, but I'd rather hear Priya talk.
I strenuously object to you doing that.
Love it. Love it. Hey, before we jump into it, do have a few announcements. The Cyber Risk Alliance, in partnership with InfraGard, has launched the Critical Infrastructure Resilience Benchmark Study. Measure your readiness for ransomware by completing the survey and getting your score. Do this by visiting securityweekly.com/CIRB. That's where you'll take the survey. And of course, if you want to stay in the loop on all things Security Weekly, while you're at the website, visit securityweekly.com/subscribe, where you can subscribe to our shows on your favorite podcast catcher or on the YouTube channel, or sign up for our mailing list, join our Discord server, and of course, we have our new streaming platform, Twitch, that we're using, and I'm still resisting doing it for whatever reason. At any rate, without further ado, let's welcome Priya again to the show. Priya, it's been a few months since you've been on the show.
Yes, I'm sorry to miss last month, but a lot of things have happened in the world, interestingly. The most exciting for all of the people out there who are wondering what the CFAA means to them and whether it's going to land them in jail, we have some answers. So the Supreme Court has finally ruled on the Van Buren case. And just to remind everybody what that is, Van Buren was a cop, and he had access by his job to a DMV database where he could run license plates and find out information for people. So he was allowed to do that by nature of his job. He didn't have to steal passwords. He didn't have to hack in. He was already in the database by permission. But then what he did with that database is he took a bribe from some scumbag friend of his and ran information on someone the scumbag wanted to know about. So it was not related to his job. It was not permitted by his job. It was being in an authorized place and doing something unauthorized by being in that place. So the question was, did he violate the CFAA? And there's sort of two parts of the CFAA, as we've talked about. The one that is, don't hack in. That's pretty clear. You're not allowed in. You're sitting at home. You hack into Expedia and change their stuff, steal their stuff. You've hacked in. This is not about that. It's the second part of the CFAA that has been causing legal problems all over the country, which is if you had permission to be there and you used the permission to do something that you were not allowed to do, have you violated the CFAA? So the question is, what is unauthorized use? Not the hacking, that's easy, but unauthorized use. And so the lawyers for Van Buren, and I would say half the lawyers in the country submitting amicus briefs to the court, argued what he did cannot be a violation of the CFAA, because that argument means anybody who uses any computer that they have authority to use that has connection to the internet in any unauthorized way is breaking the law per the CFAA. That means that all of you sitting at home on a work computer that maybe you've taken home because of the pandemic, that you're only supposed to use for work, but every now and then you buy your Amazon groceries on it, or you buy a ticket to somewhere that you're not going to use because there's another lockdown. Whatever it is you're doing, that's not exactly what you're supposed to do, according to that group, said you are in fact violating the law. And they also wanted to push this idea that it's policies, right? A company can set a policy and say, for example, you can't use your computer for personal use, and you open the internet and check your Gmail account, for example. That would be violating the CFAA. The other group, the Van Buren group, said that this is just ridiculous. This is a trespass statute, right? And as I've discussed before, the Supreme Court sitting there in Washington in 2021, most of the people on that court were born when the country was born, right? They're old people, and they're not technologically
I resemble
savvy.
that remark.
And they are trying to interpret modern laws for modern technology using a basis of law that started in like the 1400s. So trespass is one of the original crimes. Basically, I think it's referred to in the Bible. Basically, doing anything that the person says you don't have permission to do is a trespass. And the way it plays out in law usually is if you don't invite someone onto your property and they come anyway, they are trespassing. And so the other side has been advocating that the CFAA should be read very narrowly as a trespass statute, because that's what it was intended to do. So it's not for the Van Burens of the world that were allowed to sit in that seat, that were invited in, that were given permission to this database. It's for anybody who broke a gate, right? And who climbed a gate. And the metaphor used, and the one picked up by the Supreme Court, is this is a gates up or gates down question. And that is where the Supreme Court came out. They said that the CFAA is about gates. Is there a gate somebody had to climb over or break through or pick a lock on to get to where they got? And if they did that, as the other way, we've talked about in the show, internal hacking. If they did that, then they violated the CFAA. But if they didn't do that, they might have done a bunch of other things that they could be liable for under other regimes, but it's not a CFAA violation. And so that's their broad ruling. It's a victory for people who believed that it was just leading to absurdity, right? Leading to a place where all of us all the time are violating the CFAA in some capacity, because everybody uses their devices for other intended permission.
Okay, Priya, I've got to stop you for a second, because I need to ask a question here. Gates up, gates down. This is, I like, and Dimitri on Discord said the same thing. I like the idea of having a real world analogy. It makes it humanizes it, if you will, and it makes it a lot easier to understand. But I'm having a problem here. I understand where you're saying if I'm on a work computer and I open up Facebook, hey, I'm going beyond the authorized bounds, I'm doing something illegal, and that's silly. I mean, that's just silly. Now, honestly, we're blocking Facebook on a lot of work computers because of ransomware, but that's a different issue. That's not the person using it. Okay, it kind of is, but you get the idea. But what the problem is now you're saying that every single internal system I have to have granular authorization on, and if they have access to use it, then they can use it in any way they can possibly use it, and I can't say, bad person, you shouldn't have done that. That's illegal. That's going beyond your authorized access.
So I'm going to stop you there. You can, but you can't use the CFAA to do it, right?
What do I use then?
There are lots of other, first of all, companies can have internal policies, right? If it's an employment issue, there's that. If the person did it to steal the company's property, there's tons of criminal statutes and civil statutes available. This is just a question of, is the CFAA
does that theft also
available,
include,
right?
Does that theft also include employees who are currently working for the business?
If the person has taken something that they had access to but did not have the authority to take it, then it's really no different than I'm in my office right now, as you guys see by my self-portrait behind me of my tiger. Nice. There's plenty of people working in my office, right? They're all under the law what's called invitees. They're licensees, meaning they've not trespassed. I have given them express permission and invited them to be in this space, right? There's lots of things in this space. If one of them decided to put something in their pocket and leave, right, there's a ton of criminal statutes available for me to enforce my legal rights. There's civil statutes available, right? Those are still available to anybody if someone did that through a computer, but the CFAA in particular would not be available to somebody who is, for example, authorized to use my contact database, right, and decides to take the names of a bunch of my clients and sell them to a competitor, right? I would have other legal redress, but just not the CFAA.
Okay, so let's stop for a second, because with GDPR, we've got regulations, not law, and CCPA and New York State amended breach notification law and a dozen others. But we've got regulations, rules and regs that state that information has to be protected, processed, implicit consent. There's a million things that I know you've got up your sleeve, trust me. But now you're telling me that if somebody that I've given access to our customer data misuses the customer data, I, as the corporate owner, can be fined, sued, whatever, under these rules and regs, but I can only go after them for theft? What if they just simply have a spill, a breach? They haven't stolen anything. It was an accident. But they did it because they exceeded their authorized access.
So what you're talking about is a pretty complicated question, because the one issue you brought up is, what duty do you have as the business owner, right? Are you being negligent? Are you being reckless? Have you done what you needed to do to safeguard information that's yours, that's maybe you're keeping for someone else? You have a fiduciary duty. And then the second thing you're talking about is someone's intentional action, right? That would be, it would take me about 45 minutes to explain the fact scenario you gave me, but there's a million civil statutes and a million criminal statutes available for anyone who intentionally takes something they don't have authorization to, right? Even within the New York Criminal Code, there's a difference between embezzlement, which means that you had access to my money. I gave you access to my money, right? Maybe you're my accountant, maybe you're whomever, and you use that access to take it, right? That's part of the elements of the crime, is that you had permission to be there, right? So I don't have to show.
What's the corresponding one for information? Embezzlement is a great example. I love it. What's the corresponding thing for information? Because I thought that was CFAA.
So it's not the information that makes it CFAA worthy. It's the fact that it's used through a computer that's connected to the internet, right? Because your information could be in a file cabinet, right? I happen to have files. I'm a lawyer. I got lots of papers everywhere, right? It doesn't matter whether the person who's here, if someone breaks into my office, that's clear. But if someone has permission to be in my office and they start rifling through somewhere, or even I have files laying out, they didn't have to rifle, they just saw them, they don't have authorization to take them, right? It's the same thing. You could use the same criminal statutes without implicating the CFAA if someone took something that they didn't have the right to take, right? Okay. Whether it's that makes trade sense. Secrets, whether it's embezzlement, whether embezzlement doesn't, one could make a creative argument. It doesn't have to be money. You can embezzle lots of things, right? But the narrow question in front of Van Buren was just, is this a CFAA issue? Does roaming around in a place where you're allowed to be trigger that particular statute? It does not say that you're now allowed to roam around and go into rooms and take things, right? There's plenty of laws out there to prevent that. But really the question that I love, that I'm excited to ask you guys, is because these old people who probably have flip phones are the ones who, I know you guys all think it's more secure and it's better, and yes, I know that. Okay. So because they're the ones who are deciding what the CFAA means. They have said this. They said it's a gates up, gates down, right? But they didn't say what a gate is, right? And what they actually did is made it pretty complicated, because in one footnote, they said that a gate is something that there's coding to keep somebody out, right? Whether it's two-factor authentication, a password, some sort of coding.
Right, some sort of access control.
Right, and in another footnote, they said that, or the company's policy might be informative for what the gate is, right?
Oh, that's a horrible thing. Yeah.
Horrible, that's horrible, right? And so what they have done is they have left it to the lower courts. If you just to tell everyone, the Supreme Court of the United States is not a trial court. They don't ever hear evidence. They don't make decisions on rules of evidence. That's where you go when the case is over to argue any legal issues that came up over a case. But where this case started, where Van Buren starts, where all cases start, is the trial court. And in federal courts, it's called the district court. So what the Supreme Court has done is basically... Is that
the same thing as the circuit court?
No, the circuit court is the Court of Appeals in the federal. So New York sits in the Second Circuit. There's 13 circuit courts of appeals. And so it's obviously 50 states. Every state has like 1 to 4 district courts, and then several states are part of every circuit. And it was called a circuit because the Court of Appeals actually used to move around to be fair. No state had an advantage. So the district courts, which are the trial courts, are now left to have their own discretion in deciding whether that's a gate or not, right? So now you're going to have people say, all right, Supreme Court, I get it. This person was authorized to a certain extent, but is the difference between what they did and their authorization a gate? And people are going to make all kinds of really interesting arguments, right? Some are going to say, well, the policy was clear. Some are going to say, well, there was a code. Someone's going to argue it wasn't a very good code, right? And so I would love to hear from you what impact that has on you, hearing that they made this weird loophole for not defining a gate.
Well, I think it's safe to say that the CFAA needs to be repealed and replaced. Period. End of story. It was literally a law that was made in 1989, 88, 89, somewhere in there, based on a bunch of Congress critters watching hackers. And they
watched war games actually, but anyway.
Was it war games? No,
it was war games.
Thank you. I appreciate that. But the point is, you can't make a law on watching a video and having it scare the crap out of you, which happens more oftentimes than not.
That's
right?
actually how all laws get made.
Correct me if I'm wrong here.
That's how all laws get made.
All law is based on FUD.
All law is based on reaction and like the lizard brain as opposed to reason. But go ahead.
What I'm curious about is, and I'm not trying to dodge your question back to us, but the A, at least the first A in CFAA, is abuse. And has there been any court cases or interpretation of the CFAA that actually quantifies what is abuse? Since that seems to be something that the act is part of.
Yeah, that's a good question. That's actually what the question before the court is, right? The unauthorized use, is that abuse, right? And what makes it abuse is the question. Same question as what makes it unauthorized use. So that has been, and that's, like Scott touched on it. That's part of the problem, is like we're taking, these stone pillars of an ancient structure. And at this point, even though the 80s were some of my best years, some of mine and Prince's best years, that's a long time ago to be trying to retrofit that to a living, and not just living, but like living at light speed body of law and technology, right? So that's one of the problems we have, is they're trying to figure out, okay, how do we interpret those words today? And maybe Scott has a point that it's never gonna work. You can't alter that dress to make it work anymore. You have to just say, given where we are and given where we're going, let's write this so that it means what we want it to mean and does what we want it to do. And, with all laws, they might be 3 or 4 lines long. And there's a ton of jurisprudence on like, how do you interpret the law? And, what if a word is unclear? But really what everybody looks at is congressional intent if it's not totally clear. And that means all the garbage that the Congress people spew while they're debating the law, that is what comes into play. Right? When one party goes, well, they meant this and the other meant that. Maybe I'm persuaded that maybe we do say, no, let's just write these words down. What we had was great. It doesn't work anymore. Here's what we're doing and here's why we're doing it. And we're very clear, this is the type of behavior, and this is what they do all the time when they pass laws. We want to give examples of the kind of behavior we are saying is unacceptable and will face criminal sanctions, right? And maybe it is time to do that, because otherwise you end up with the ancient court and, God, I hope they don't watch this and hate me for it, but the ancient court saying things like, a gate could be a code, could be a policy. Like, did you just make me mud? I don't understand. Like, how?
Priya, I can literally see the court, the next time you go in front of the Supreme Court, I can see one of the judges leaning down going, the ancient court, Miss Chaudhry. So,
I've had versions of that happen to me before.
What I'm hearing is, and I think the heart of the issue, and guys agree or disagree with me, that's fine. But I think, at least in the beginning, the CFAA, as the court seemed to support, was all about access. Where we see a difference and it existed back then, but I think it's more to the point these days, is what we would call privilege. You have access to a system, you have access to a computer or network, and then there's this idea of least privilege, of need to know. These are principles that have existed since the beginning, hardly ever enforced. You have administrators of all different flavors that run around with administrative access when they really don't need to have administrative access. They could be doing things through, stored procedures and scripts and things that give them limited access. So, and it makes it complicated because very few companies actually enforce the way they should be, I should say. The idea of privilege and limiting access, and that's a different issue than simply gaining access or having access to a computer, a network, a domain, an environment. Guys, agree, disagree? Is there more to it, or does it boil down to pretty much those two elements?
I think there's a lot more to it. I think there's always going to be edge cases. And I think it's going to be a significant issue for a very long time. For example, let's talk about policy. Priya, you mentioned policies are an acceptable gate. Okay, great. Has the person involved signed the policy? Have they indicated they'll be compliant? Is it a properly written policy? Does the policy include sanctions? Blah, blah, blah. There's 100 questions you can ask about a policy before you can determine it's appropriate. Okay, probably not 100, I'm exaggerating, but you get the idea. So you've got so many different edge cases that are going to be put in place based on this type of issue.
There's always going to be edge cases. It doesn't matter what you deal with, right? So saying, well, there's going to be edge cases, it's kind of taking the easy way out, isn't it, Josh?
No, not at all. Edge cases are something you have to be careful of. It's not a cop-out at all. As a matter of fact, it's a reality of the situation. So there's always going to be edge cases, so that you have to understand what those are.
I think there's nothing but edge cases, in which case...
Yeah, the stuff that we deal with now.
Edge case, you're right. Isn't a good descriptive
term.
So
let me ask you guys this is kind of my question for you. So let's say the CFAA has now been interpreted by the revered, amazing Supreme Court in its wisdom, and they said it's gates up or gates down, right?
Right.
And they said, okay, Jeff, Josh, and Scott, you tell us what a gate means.
To me, it has nothing to do with privilege in any way, shape, or form. It all comes down to what the access is, what's happening to the data. Right? We as a industry, as a society, have been moving faster and faster down to what's being done with data. Data-driven businesses, data-driven mining operations, data control, data access. So the gate is around what happens to the data.
So that's not at all what they said, right? They said, we find that if there's a gate and someone climbed over or broke through the gate, only then is it implicated. So the question to you is, how do you define the gate? What you're saying is, I don't like their ruling. I want to hear, Scott, how you, if they asked you to sit as the 10th person of the court, what you would say, everyone, hear ye, here's what a gate is.
Right. If you asked me to define what a gate actually looks like, it would be, to me, access control.
And what is that?
So who has access to the data? When did they have access? Under what purpose did they have access? Under what dual? I'm trying to use some legal words that are just not making sense in my head. Duality of control.
Stick to the IT words, Scott.
Right. Jeff.
Well,
thank you.
It's interesting, Scott. You're giving me a policy answer, right? You were using one of their footnotes, which says the company decides. You're not. Yeah, I haven't yet heard
that's an interesting way of looking at it.
So let me take it for a second, if you don't mind. So Scott was giving you a bit of a policy answer, but that's because that's where the controls come from. He's actually very right in a lot of ways. Let me expand on this a little bit using slightly different language.
Yeah, go for it, Josh.
So authorization, which is what you're talking about. Do they have authorization to see that data, use that data, to be, and I'm using data as sort of my catch-all term, if that makes sense, okay? But do they have authorization to use that data, to see that data, to touch that data? It's the who, what, how. So who is authorized to see that data? What data are they authorized to see, and how are they authorized to see it? Okay, so you've got who, what, and how. Now, there's also some purposes, like can you use that data to look at, but not to copy, things like that. But we're going to ignore that for the moment. So for right now, we're talking about the who, the what, and the how. And then you implement controls. Okay, these are the technical controls, and that's my answer to you. Is I would say it has to be a technical control, not a policy control. It needs to have a positive verification that the person involved, I'm using people just as an easy label, because you could have processes, service accounts, etc. But I'm saying that the person or identity involved has a authorized right to touch the data, see the data, use the data, etc. Okay? I wouldn't use a policy control in that there's no technical control. It's simply a, hey, you have a policy, you're not allowed to touch that data, don't anybody go near it. I wouldn't leave that, because that to me is not a definitive gate. So I would say there has to be a technical control.
I agree with what you're saying, Josh, but I would argue and say that it's both. It's both the technical control and the policy that backs it from a corporate guidance.
Oh, the policy is there, yeah, but the technical control is the gate. The technical control is the gate.
But what I'm saying
is
that
the why is there a gate there?
Right, you need both of them because the policy. Remember, the policy carries down the vision and strategy from the C-levels and the board. Right, the policies are what govern the way the business works. The technical controls are the implementation of that policy. Right.
Well, I think that
you can't have one without the other. I mean, you can.
I'd love to hear what Jeff said.
Hold on. It just hit me. You can have one.
I didn't realize you weren't done.
No. You can have one without the other, but that's sort of like you can be secure and not be compliant, but you can't be compliant and not be secure.
Maybe,
yeah,
but
let's go with that.
I think what you're getting at, Scott and Josh, is what I would call, and I'm trying to juxtapose legal terms with ITIS terms, which I think in and of itself might be a problem. But enforcement, I think, is where we think one, you can't have one without the other. So the gate analogy, probably from a legal physical gate perspective, there probably isn't a written policy in a household or a business that says thou shalt have a physical gate that controls entry or access into your yard or something. Although there might be stipulation in the law that says, well, if you don't have something like that, people can just waltz in and waltz out, which is actually a question I have for Priya is, in the ITIS sense, most things that companies do from a security or IT perspective in terms of how they deploy things, how they administer things, they're generally driven by a corporate, hopefully it's a written down policy that says, which I always try to tell my customers, it's sort of like the 10 Commandments. It's a series of thou shalt statements. Thou shalt secure your data. Thou shalt limit access to your environment, and so on and so forth. But the way that those thou shalt policy statements are enforced is through very often technical controls. Sometimes there are procedural controls as well, but it's the enforcement or the fulfillment of the policy goal, policy statement. Is that making sense in terms of you're seeing through a legal perspective?
So interesting because as a lawyer, and I think the legal community, which for the most part the lawyers involved in emotionally invested in this case are not necessarily tech people. The legal community found their answer to be pretty disappointing and confusing. But I'm fascinated by the fact that all three of you basically have the same answer as the Supreme Court, which is it's actually both, right? That you need some kind of technical control, and then
we missed our call,
Priya,
guys.
I gotta explain this. Wait. So Priya, let me explain this for real quickly. You got to understand that from our point of view, we're all used to dealing with users, your standard non-technical user. And from our point of view, while I can write policy until the cows come home, unless you put a technical control in place, they will ignore or literally deliberately ignore policy. So we have to put the cattle chutes in place to direct them where we need them to go, which are the gates that you're talking about, quite literally. Mm-hmm. And so the policies are there to explain why we have the gates, but the gates are there to make sure they go to the right place. Right. And with that, Jeff?
Yeah, let's take a short recess. We'll come back with the second segment. We'll obviously pick up the conversation again. I want to ask Priya a little bit about some of the legislation that's coming out, what the White House is doing, even back to the EO, which is ancient news at this point. It's 4 or 5 months ago. But sit tight. We'll be right back.